Alright, here's another one. Now, as time has gone on, my understanding is there is a description that makes a difference between concepts of contract regarding equity versus contract and performance, for instance, of a governmental duty, which is something that I was trying to get to know about today. Right? Specifically through the law, through actual explications of particular kinds of legal concepts that have been argued in cases, not all of which went before the Supreme Court. Right? And the distinction between what does it mean to engage a contract in a proprietary capacity versus some other form of contract, for instance, an agreement or a contract that one would sign in order to receive services from the government. And so, if we're discussing, well, what is it we're expecting to get from the government, and if we get it, are we satisfied? And are the means by which we obtain it somehow a consideration of the expression or exertion of our power as the people? And so, if we do not take the responsibility to say, I need to assure that that which I acquired from you was done with my authority, i.e., done with the authority I vested in the Constitution, which authorized you to be a representative of me in performance of duties that were delegated to you based upon your relationship with the constitutional process. Well, if you don't ask and you don't tell, then who are you? See, this is very important in a specific matter, right? Because there are a few other things that ended up supporting this. For one thing, was a distinction of a particular argument. See, in this particular explication, there was some consideration that Justice Marshall wasn't very important. And yet, as I acknowledge in here, there are several cases that are absolutely essential to the history of American finance and banking. One of the first of the major cases of concern was actually authored by Justice Marshall, and he took a very significant consideration in articulating the understanding of the authority that the people delegate to the government through the Constitution. And specifically of concern were matters related to constitutional conventions. And he has a very important explication in that opinion about the role of the constitutional conventions in the early days of the America and in the early days of the states, including the states and the relationship of the Articles of Confederation, and then the states and their constitutional processes, as well as the federal constitution and the process of convention that happened after the federal constitution was composed. And see, this was his understanding of the authority that members of the legislature had as merely an expression of the delegation of the people's power. And to read that is actually very, very informative. It's very, very dense. But it also brings up another consideration, right? Which is mentioned in here, which is a consideration of the actual fact that, thus far, so far as I know, a constitution gives a specific kind of indication concerning honoring of terms and contracts from the Articles of Confederation. So far as I know, I have yet to find any case that challenges that. And this brings up a very important question about concepts of pre-existing conditions and what's considered to be a contract that is acknowledged prior to a constitutional change versus a contract that is rendered null and void because it is not in compliance with the Constitution, even if it tries to draw down its authority based upon being in lineage with contract claims that predate the Constitution, and yet may otherwise be within a lineage of a body of law that has been acknowledged in the process of consideration or even adjudication of constitutional concerns. This comes up in many different ways. And there's been a very significant controversy over the last couple hundred years within the United States about what actually has constitutional authority. Whether we're talking about considerations of codes of law from outside of the United States in relation to the domestic law, and some justices are very adamant that is not appropriate. Or other justices have argued that it is important to contextualize American constitutional elements within an understanding of its relationship with considerations of what's the standards or even considerations of moral turpitude internationally, as well as what considered to be a acknowledgeable claim regarding a contract relationship. But at the same time, There's a very real and practical consideration about what is allowed to be considered a consistent claim, including a claim that tries to identify itself as being in lineage with a claim that predates the actual Constitution, including changes to the Constitution, such as the right of women to vote and the consideration of slavery. Has there ever been a case that is actually seriously challenged the stipulations within the Constitution itself regarding relationship and consideration of contracts that were valid under the Articles of Confederation? Why not? That's one thing. That's one thing that this brings up. But in consideration of this, it also brings up this understanding of the authority of the people in the contract. And I contend that with that case and with the other argument, including the one that is presented in accordance with consideration of Fletcher versus Peck, there's ample evidence to say that the Constitution is itself a contract with the people. Contract that the people have with members of the government that are delegated to represent them. Their authority extends no further than the Constitution. So alterations to the Constitution that are unconstitutional do something to the authority of the people. Who is authorized to actually change the Constitution? So this is a very significant consideration.